Hello, and welcome to the show. I am Jacob Davidson, and I am from North Texas. It is a pleasure to be here again. Forgot part of my setup. My hair looks whack. It's because I took a shower. I need to have a more. Yeah, pop out chat. I need to have a more involved intro. That would be nicer than just. Hi, I'm Jacob Davidson. I also realize I need to speak more concisely because when I listen to myself, I sound like I'm slurring words or something. Either that or me trying to sound concise is exactly what I'm hearing, and I am just not a good voice. I need to stop getting distracted. That's what I need to stop doing. Let's see here. So I can look at the camera while I'm talking as opposed to looking like that all the time. The topics today are very limited, but simply the School Voucher program that I mentioned before. I'm just going to be reading an opinion piece based off of, or a countering opinion piece from the one that we read yesterday. I'm going to actually be going over the 53-page Senate 8 bill, seeing what it adds, what it takes away from the current education system here in Texas. And then after that, I'm going to be reading over the Trump indictment charges. And hopefully that will be a good enough, that'll be all that I have for the show. I'm hoping it lasts a little bit, because I don't want the show to end so soon. So hopefully it'll all play off exactly how I want it to go. On to the first topic of the show, and that is the Proponent. That friendly article that was written that we saw yesterday whenever we were covering the why it's bad from the former House Committee ACOX. School choice is good for families and students in public schools too. Here's how. An opinion piece by Alexander William Salter. I'm gonna start doing that kind of thing more often. Hopefully reading it more concisely and who and what it is. So here above is DeSantis came to Seventh-day Adventist School in Miami to sign the bill into law. Can a governor just take a bill wherever they want and then sign it there? I never actually really thought about that. The battle for school choice is heating up. Texas is one of the leading fronts, but lawmakers in Florida, Iowa, and Utah are also leading the charge to make students' education dollars transferable, rather. Lawmakers are riding a major surge in popularity that began in spring 2020. Polling data shows more than 70% of voters support the broad concept of school choice. Public officials have a once-in-a-generation opportunity to enact major reforms that put high-quality education within every student's reach. But not everyone is convinced. State representatives, often from rural districts, have previously stopped school choice bills short of the finish line. Representative Ken King, a Republican who represents a panhandle district, declared voucher bills dead on arrival. Citizens who otherwise favor freedom and choice can be skeptical about whether transferable student funding is right for their state. Protesters in Utah recently expressed concern that school choice drains so much money away from public schools. Does embracing school choice mean pulling the plug on traditional public schools? The answer is no. And this is inherent in the Texas bill, because whenever in the topic it reads that schools with 20,000 students or less will not receive cuts from their funding based off of lost student attendance. Does embracing school... Okay, I read that. Choice doesn't defund or destroy public school systems. In fact, the best social scientific evidence shows that school choice can improve them. Transferable funds is a complement to, not a substitute for, the existing system. By ensuring all students have the resources to find educational environments that's best for them, school choice improves education outcomes across the board. I will have a couple of opinions that I forgot that I was going to talk about, or that I wanted to talk about today. So I will make sure to go over those before I move on to the actual bill itself. First, let's consider how school choice affects student achievement in traditional public schools. 28 student studies explore this question dating back to 2002. The studies mostly focus on voucher programs, but several considered tax credit and private scholarships as well. The evidence is clear. 25 of these studies find school choice raises test scores for students who remain in the existing system. Only 2 find any negative effects. The evidence clearly points to spillover benefits for traditional public schools, which should be much more widely known and discussed. The evidence is clear. The evidence is here. So 25% or 25 of these studies find school choice raises test scores for students who remain in the existing system. So what this is saying is that students who choose private schools, that public school students have improved test scores, which might have something to do with less students for teachers to deal with, or the bad students of the system leave the public schools to find a school that they want and actually go and study, hopefully. Hopefully, that's a wishful thinking idea, though. It's still warm. Today I'm doing Earl Grey tea Sebastian's Morning Earl Grey tea from The Dragon's Treasure. repost the link. In a minute. How about the effects on teacher compensation? While this question hasn't been researched extensively, there are a handful of promising results. Out of 6 studies going back to 1994, 5 find positive effects and 1 find mixed effects. The takeaway is that school choice usually results in modest salary increase for public school teachers. These results may seem counterintuitive. The explanation comes from basic economics. The power of competition. The more options students have, the better existing schools must perform to attract and retain students. Traditional public schools are not totally stagnant and impervious to improvement. They're capable of meeting this challenge if they have the right incentives. School choice ensures they do. Just as important are the additional options for teachers. School choice puts them in a better bargaining position by giving them alternatives where salary considerations aren't constrained by the administrative and bureaucratic hurdles of traditional public school systems. Outside options mean inside benefits. Too often we think transferable funding only benefits students, but this reflexive attitude is mistaken. School choice is not a zero-sum game with teachers on one side and families on the other, writes Corey DeAngelis, a leading school choice scholar and advocate. He's right. Competition can help all stakeholders in education debate get what they want. We mustn't fall into the trap of reducing school choice to another front in the culture war. Growing concerns about critical race theory and other questionable topics in K through 12 curricula are fueling the school choice debate. But in terms of basic value, the public agrees on much more than it seems. Everyone wants an education system that promotes familial and national flourishing. We need reforms that help public and private schools perform at their full potential. Viewed this way, school choice becomes a means to an end question. Does transferable student funding improve the well-being of students and teachers? The research on school choice says yes. Governor and state legislators deserve credit for prioritizing strong education systems. The best reforms create new options while strengthening old ones. This is exactly what transferable funding does. Everyone, even for students and teachers who choose to remain in public schools or public education, school choice is a winner. Alexander Williams Salter is Associate Professor of Economics in Rawls College of Business at Texas Tech University. There he is, right here. Well, let's go to its research. The evidence is clear. 25 of these studies. One, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25. May have double counted one of these. DOI.org. Given the significant growth rate and geographic expansion of private school choice programs over the past 2 decades, it's important to examine how traditional public schools respond to a sudden injection of competition for students. The problem is, it seems to be that there needs to be a competition. And public schools, for the most part, seem to be stagnant without competition. I was talking yesterday about the failing students' grades that we saw mentioned. And I'm thinking the way to fix that is by making it so public or private schools cannot charge for summer school to catch up students. I had that idea while working, so hopefully that's a better idea than just suck it up. I think that's what I was talking about. I was listening to myself. Hey, Joseph. I find it beneficial to listen to my own streams, especially the one I did last time while I'm at work, because it helps me think my process through and cut myself where I need to be. So I can't quite remember exactly what I said to the comment of what did I say? The general idea was that of course private schools are going to have lower grades for people transferring from public schools because public schools didn't teach them to meet that requirement. It was something about grades decrease whenever public school students get to private schools because they can't meet the homework load. The solution to that is to give remedial classes and summer schooling basically to the public school students who move into the private schools for free, or a benchmark, so that way you can get them up to snuff. Because if you're going to put public standard students to private standard schools, that seems like it could open for predatory practices where a student comes in and is then made to do remedial classes to meet the new standard. So as a way to safeguard that, just make it so, or negotiate it so that they have free remedial classes. How you doing, Joseph? Should probably lower the camera now that I'm thinking about it. And to ACOC, I will retract a fair amount of my criticisms towards him. He might have the best intentions. I was waking up and I might have been overly critical of him. I just don't think the sunk cost fallacy works for public schools. And it's alright that people care about them. I hope that people care about them enough to want to fight for them. However, there seems to be a significant failing towards the public school system that needs to resolve or have conflict to resolve those issues. Not to say it needs to be manufactured out of nowhere. However, to improve the public school system, we need something to make it so it needs to be better. Hopefully public school choices or private school choices as a voucher system will help encourage that growth. Otherwise, it's a lost cause entirely, and it's just a waste of money. However, I still hold my previous opinion that misused money from a private person is still significantly better than misused money from the government. I'd rather the parent make the mistake 9 times out of 10 over the government making the mistake 9 times out of 10. Or 1 time, yeah. Said something redundant there. Pretty good Earl Grey tea. So I'm far more in favor of this opinion piece. I like it a lot more. Public schools educate all students. I once heard a parent register a student after 2 years of no classes. The 14-year-old was years behind in academic development. That's what I was thinking about. So the concept was more teachers or smaller schools for more one-on-one time? No? Something like that. Maybe there are some students who flourish better in a larger group environment, and there are teachers who teach better in larger group environments. Maybe that's a myth. However, I do like the capacity of choosing. And it actually makes sense. If you can give more public school students the choice to go to a private school, they can get put in a smaller environment. It also then spreads that one large environment out further, making smaller environments for teachers to teach. Of course, that'll invariably increase the environment for one other teacher, but for the public school system, it'll increase efficiency by decreasing class size. This academic development being behind thing actually reminded me. So the math issue was because it's sequential. What you learn adds from the last one. So math 1 leads to math 2, math 2 leads to 3 for algebra, calculus, trigonometry, that kind of thing. A remedial class specifically for that. Help the student learn to come to the current understanding. It is actually a fair assessment and a fair thing if a student can't meet the new requirements because their math skills are not developed because they just haven't been taught well. And whether that's a failing for the public schools system is for the public schools to try to fix. The public schools started a plan to accelerate the newly enrolled students' learning. At the same time they did that, the school offered hundreds of other students college classes, AP classes, career technologies. There's absolutely nothing wrong with choosing to homeschool a child or choosing to send them to a private school. I know lots who do this successfully, but we as a society don't pay for that. We pay for public schools because the article offers multiple studies that point to a different conclusion than vouchers will destroy public schools. You realize that school choice follows the students. I doubt that the total per student allocation budgeted by the school districts will ever be allowed to transfer with the students. This means that per student funding at the government-run school will actually be higher. Simple arithmetic. If I have 1,000 students and budget $1,000 per student, that's 1 million total. If 100 students leave and are able to take $100 per student with them, that removes $80,000 total dollars. So now the district has 9. Okay, yeah. The district now has 920,000 for 900 students, which equals 1,022 students. $1,022 per student. More, not less. I posit that with no oversight into homeschool, there is something wrong with it. I've seen too many poorly educated homeschool students in my time here in Texas. That's, yeah. It would be nice to see every homeschool succeed, but it's a natural conclusion that there are going to be private school students or homeschool students that fail because the parent cannot meet that requirement. Whether that's so wrong is a question for somebody else. I still think it's better for a parent to fail their student or fail their child with the best intentions than a public school system fail the student with presumptively bad intentions. Baloney. Public funds belong in public schools. School choice is just as nice. Safe way to say public school instruction. Oh wow, this person. Pay for your kids' private education. Also pay for others' public education. Why can't your tax or education go pay for your students' education? Yeah, it is a problem. The idea that public funding belongs in public schools. Like, it seems to be a deadlock for some people. This was last 2 months ago. It's a good idea. It was worth testing. And if it fails, we know better. I hope it doesn't. It'd be nice not to play around with education and the growth capacity of our kids. Would be nice. All right. Going from that, we're going to move on to the bill portion of this text or the stream. So, Texas Senate 8 bill, or Senate Bill 8 in Texas. It's a bill introduced by Brandon Creighton, and it is the bill that allows the voucher system. So for reference, anything that's underlined is added, and anything that has a strike through it is removed. Okay. Sorry, I was just my kettle trying to get some warm water again. Is there a way to make a noise gate? Alright, testing. I need to figure out at what decibel point that comes in at. Or I'll just listen to the stream at this moment. 30 minutes in. Alright, that's for me. That's my note. Let's get into this. Just gonna post the stream link one more time in the chat. A bill to be enacted, Senate Bill number 8, or a bill to be entitled An Act. Relating to public education, including parental rights, public school responsibilities regarding instructional materials, and the establishment of an education savings account program. Be it enacted by the legislature of the state of Texas. Article 1, parental rights, school liberty, school libraries, and curriculum section. Or curriculum. Section 1.1, Chapter 1. Education Code is amended by adding Section 1009 to read as following. Infringement of parental rights prohibited. The rights granted to parents under the... Shit. Forgot to set a timer. The rights granted to parents under the laws of this state include the right to direct the moral and religious trainings of the parent's child, make decisions concerning the child's education, and consent to medical, psychiatric, and psychological treatment of the parent's child under Section 1501 or 15101. Family code may not be infringed on by any public elementary or secondary school or state governmental entity, including the state or political subdivision of the state, unless the infringement is necessary to further the compelling state interest, such as providing life-saving care to a student, and narrowly tailored using the least restrictive means to achieve that compelling state interest. So it's applying strict scrutiny to schools. For a start page. God, this dark mode thing is so great. Parent-child relationship. Okay, so 1501. Rights and duties of parents. The right to have physical possession and direct moral. Okay. Duty to care, control, protection, reasonable. Duty to support the child. The right to consent to the child's marriage enlistment. The right to represent the child in legal action. So it's just applying the laws from 15101 to hey y'all. Hey Saran. I'll see you whenever you watch it on the replay, or well, hopefully you'll enjoy the replay. I know that I won't be able to interact with you in that time unless you comment. So those are the added sections of it, of this first area. So they add this whole section 109. Education Code is amended to read as follows: except as provided by subsection E, a person may appeal in writing to the commissioner if the person is aggrieved by the school's laws of the state or actions or decisions of any school district, board of trustee. Okay, wait, shit. I'm going to very quickly need to drink this tea because the portion that's stuck in here is still brewing because it's in contact with the tea. And I don't need it there for another few minutes. Okay, so the school laws of the state, or they remove that or. Okay. Oh, okay. The school laws of the state or actions or decisions of any school district of trustees that violate the school laws of the state. So it used to be or a provision written, but now it's that and a provision of written employment contract between the school district and school district employee if the violation causes or would have caused monetary harm to the employee, or the grievance procedure adopted by the school district under section 26011. Complaints. The Board of Trustees of each school district shall adopt a grievance procedure under which the board shall address each complaint that the board receives concerning violations of the rights guaranteed by this chapter. Hot. Hot. Hot, hot, hot. The Board of Trustees of the school is not required by subsection A or section 11-1511B 13 to address a complaint that the board receives concerning a student's participation in any extracurricular activity that does not involve a violation of a right guaranteed by the chapter. So they add this grievance portion in. Section 1003, section 11-16-1, Education Code is amended to read as follows: frivolous suit or proceeding in civil suit or administrative proceedings brought under state law or rules. They crossed something out. Against an independent school district or an officer of an independent school district acting under the color of office, the court of another or another person authorized to make the decision regarding the proceeding may award costs and reasonable attorney's fees if the court or other authorized person finds that the suit is frivolous, unreasonable, and without foundation, and the suit or proceeding is dismissed or judgment is for the defendant. I'm assuming this proceeding portion has something to do with school boards. Okay, sorry. Something weird happening in locals. Superseding this or judgment is for the defendant. Yep. So this and that. The court 25035 Education Code is amended to read as follows: Transfers between districts or counties. At A, the Board of Trustees of two or more adjoining school districts, or two or more school districts, or the Board of County School Trustees of two or more counties may, in accordance with sections 32, 33, 34, for transfer and assignment of any student from the jurisdiction of one board to that of another. I'm pretty sure. Yeah, we'll need to check this one out. So 32, 33, and 34. Basis for assignment or transfer. The Board of Trustees of a school district, the Board of a county school trustees, or the person acting for this board must take the decision concerning the assignment or transfer of a student on an individual basis and may not consider as a factor in its decision any matter relating to national origin of student or the student's ancestral language. So no discrimination on ethnic origin or national origin. Transfer, assignment or transfer on petition of parent or person standing in parental relation to any student may by petition in writing either request the assignment or transfer of the student to a designated school or to a school to be designated by the board, or file objections to the assignment of the student to the school to which the student has been assigned. 34 is then hearing action on petition appeal on a. If a hearing is not requested, act on the petition not later than 30 days after the date of the petition is submitted and notify the petitioner of the board's conclusion. Or, if a hearing is requested, designate a time and place for holding a hearing not later than 30 days after the date of the petition is submitted. If a hearing is requested, it shall be conducted by the board in compliance with this section. The petitioner may present evidence relevant to the individual student. The board may conduct investigations as to the objection or request, examine any student involved in employ agents, professional or otherwise, for the purposes of the examination and investigations. So the board may conduct investigations and also employ professionals or not professionals. Oh. I don't like the later one. The board must grant the request made in the petition unless the board determines that there is a reasonable basis for denying the request. The decision of the board, either with or without hearing, is final unless the student or parent, guardian or custodian of the student, as next friend, files exception to the decision of the board as constituting a denial of any right of the student guaranteed under the United States Constitution. If an exception is filed under subsection A or subsection E, the board may reconsider its decision. If the board has not ruled on the exception before the 16th day after the date of the filing, the exception is considered overruled. If the exception is overruled, an appeal of the board's decision may be filed in the district court of the county in which the board is located. The petition must be filed no later than 30 days after the date of the board's final decision and State the facts relevant to the student that relate to the alleged denial of the student's rights under the United States Constitution. Ooh, I hopefully am getting used to reading consistently, concisely. Hold on. Still warm. Transfer of students involved in sexual assault. These are applied as the same as 304 or 34. So sexual assault transfers, and what's the other one? Victims of bullying or have engaged in bullying. Transfer students residing in household or receiving special education. So the three different, or the special statutes that relate outside of just outright petitioning for any reason is sexual assault, bullying, and special education. Transfers in accordance with sections these. Arrange for the transfer and assignment of any students from the jurisdiction of one board to that of another. And the removed section was, in the case of the transfer and assignment of a student under the section, the participating governing boards shall also agree to the transfer of school funds or other payments proportionate to the transfer of attendee. That was removed, and here is what's added. A school district may deny approval of a transfer under this section if the district or a school in the district to which a student seeks to transfer is at full student capacity or has more requests for transfers than available positions. At the time a student seeks to transfer, the student is suspended or expelled by the district in which the student is enrolled, or at the time a student seeks to transfer, the student is suspended or expelled by the district in which the student is enrolled. Or approving the transfer would supersede a court-ordered desegregation plan. A school district that has more applicants for transfer under this section than available position must fill the available positions by lottery and must give priority to the applications in the following order. Students who are dependents of an employee of the receiving district and students receiving special education services under subchapter A, chapter 29. Students who are dependents of military personnel, students who are dependent of law enforcement personnel, foster care who are subject of court order modifications of an order establishing conservatorship or possession and access, who are siblings of a student who is enrolled in the receiving district at the same time that the student seeks to transfer, residing in the receiving district, and new section here. A student who transfers to another school district under this section may not be charged tuition. Student is included in the average daily attendance of district to which the student transfer begins the date the student begins attending classes at that district. A receiving school district may but is not required to provide transportation to a student who transfers to the receiving district under this section. I need to take a minute because I realize I'm starting to slur my words together. And my jaw's getting weird about it. Of course that would happen. Sorry for the dead air, I just need a moment. I can speak about my opinions on things for hours on end and talk and talk and talk, but reading documents in a concise way that shows that I have a good reading skill is rough. Hopefully you guys are enjoying the show so far. I know it's not the sexiest thing. However, I hopefully have made it sexy enough. Not enough tea in the kettle. Alright. A receiving school district may revoke at any time during the school year the approval of the student's transfer if the student fails to comply with conditions specified in the agreement, that is, the circumstance specified in the Student Code of Conduct under Section 3701A1. Discipline. 01A. Section 3001A1. I believe this is it. Specified circumstance in accordance with this chapter. It's just a discipline thing, it seems. B. Special condition to A2. Conduct for which student is required or permitted to be removed from class and placed in disciplinary alternative education program under Section 3706, or conduct for which a student is required to or permitted to be expelled from school under Section 07, or fails to maintain specified school attendance rate. 105 section is amended by amending sections A, C, D, and E and adding sections A1 to read as follows. As provided under section 15101 Family Code, a parent has the right to direct the moral and religious training of the parent and make decisions concerning the child's education and consent. Yeah, this is what we read initially. That was the main idea. A1. Parents are partners with educators, administrators, and school district boards of trustees in their children's education. Parents shall be encouraged to actively participate in creating and implementing education programs for their children, unless provided by law, a board of trustees administrator, educators, or other person shall comply with section 109 and may not limit parental rights or withhold information from parents regarding the parent's child. The one shall provide for procedure consider complaints that a parent's right has been denied. Develop a plan for parental participation in the district to improve the parent and teacher cooperation, including the area of homework, school attendance, and discipline. 3. Removed each board of trustees shall cooperate in the establishment of ongoing operations. At least one parent-teacher organization at each school in the district to promote parental involvement in school activities, and provide information about parental rights and options, including the rights to withhold consent for or accept the parent's child from certain activities, and instructions that address the parent's rights and options concerning child's course of study and supplemental services, instructional materials and library materials, health education instructions under sections 2804, instructions regarding sexual orientation and gender identity under 2843, school options including virtual and remote school options, immunizations under 3801, gifted and talented programs, promotion, retention, and graduation policies, grade, class, rank, and attendance information. God, these are burning through real quick now. State standards and requirements, data collection practices, healthcare services, including notice and consent under 2683G, and M, the local grievances under sections 2611. Give me just a minute. I need to take a minute and walk around. I am dozing off. So, I'll be back. Bathroom break, everybody. Take a minute. Have fun. I'll be right back. Alright, I'm back. Sorry about the wait. I just needed to take a moment to stretch and relax and sip some tea and refill my kettle. This studio mode, holy shit. So I learned some tricks behind the scenes to kind of help maneuver myself, which is nice. So I just had to add all my sources on like the starting screen behind Be Right Back and camera focus screen that I've got. So that way I can change like this or this thing. So I can go from browser to browser without you guys having to see it. And I'm learning that the studio mode is actually very effective. Because right now I'm looking at a purely me camera right now, seeing the fidelity of it. But you don't. And this is all just a preview. You can hear the clicking, but nothing's happening. Unless I double click it. All these cool tools are making me pretty excited about it. So back to the bill. I'm only 7 pages in to this, by the way. I'm probably going to come back to this another time, like everything else, and then just go to the Trump indictments, which is way shorter. I don't know why these bills take so long. And I don't know, well, I kind of get it. And I don't know how Rackets went and read through a bunch of like court indictments or whatever. It's probably because the facts of the case were a lot more fun than just going through this and bashing your head into a wall. I'll probably finish off at page 12 or 15. We'll see. 2612. Right to the... This is amendment. Chapter 26 Education Code is amended by adding sections 2612, 26, 61, and 83. The right to information regarding parental rights. A parent may request in writing from a school district superintendent information regarding parental rights under Title 1 or this title. I need to take a moment and read carefully. If the superintendent denies a request made under subsection A or does not respond to the request within 10 days, the parent may appeal to the district's Board of Trustees. The Board of Trustees must include an appeal made under subsection B in the business of the next board meeting after the date the appeal is received. 26. The right to select educational setting. A parent is entitled to choose the education setting for the parent's child, including public school, private school, or homeschool. The right to request instructional material review. The Board of Trustees of each school district shall establish a process by which a parent of a student, as indicated on the student registration form at the student's campus, may request an instructional material review under Section 31-236 for a subject area in the grade level in which the student is enrolled. A process established under Section A may not require more than one parent of a student to make a request. Must provide for the Board of Trustees of the school district to determine if this request will be granted either originally or through an appeal process, and may permit the requesting parent to review the instructional material directly before the district conducts an instructional material review under Section 31-236. If the parents of at least 25% of the students enrolled at the campus to the Board of Trustees of the school district in the campus is located a petition if more than 25% of students if the parents of at least 25% of the students basically at the school district is located, petition for the board to conduct an instructional material review under 31. The board shall conduct the review unless by a majority vote the board denies the request. A review conducted under this subsection shall include a review of instructional materials for each subject area or grade level specified in the petition. The commissioner may adopt rules to implement this section. Section 2683, rights to inform regarding mental, emotional, and physical health and health-related services. The agency shall adopt a procedure for school districts to notify the parents of a student enrolled in the district regarding any change in services providing to or monitoring of the students related to the student's mental, emotional, and physical health or well-being, or the district's ability to provide a safe and supportive learning environment for the students. Procedure adopted under subsection A must reinforce the fundamental right of parent to make decision regarding the upbringing and control of the parent's child by requiring school district's personnel to encourage a student to discuss issues relating to the student's well-being with the student's parents, or facilitate a discussion under subdivision 1. A school district may not adopt a procedure that prohibits a district employee from notifying the parent of a student regarding information about a student's mental, emotional, or physical health or well-being. The thing that throws me off is the wording of these. I get mental, emotional, and physical health or well-being. But the way it's like physical health or well-being kind of kills the flow of health, mental, emotional, or blah. Or a change in services provided to or monitoring. A change in services provided to or monitoring. Encourages or has the effect of encouraging a student to withhold. Prohibits a district from notifying. Okay, so a district may not adopt something that prohibits them from notifying the parent regarding health, changes of services or monitoring, encourages them to withhold, or prevents a parent from accessing education or health records. Subsection A and C do not require the disclosure of information to a parent if the reasonable, prudent person would believe the disclosure is likely to result in student suffering, abuse, or neglect, as the term section family code. This gets this thing out of the way of the whole abusive parent aspect. Reading is rough. I think I just need water. Hold on. I just realized I had been muted the entire time. I had muted my mic hardware-wise, and then unmuted myself in the software. I had to take a break. I was hungry, and I needed something to eat. I figured I may as well eat it all already. Sorry for the break. We're back to the show. I needed to talk to somebody, or I ended up talking to somebody. Very sorry. Very, very sorry. So we're starting back here, and then, or starting back up here, and then moving down. I'll end this on 12 pages, and then I'll go to the Trump indictment. And then we'll come back to this another time. Subsection D, subsection A and C do not require the disclosure of information to a parent if reasonably prudent parent would cause harm to a child or neglect. A school district may not discourage or prohibit parental knowledge of or involvement in critical decision affecting a student's mental, emotional, or physical health or well-being. Any student support service training developed or provided by school district to district employees must comply with any student services guidelines. Oh yeah, I rewinded it. The actual stream. Any student support services training development or provided by a school district to employees must comply with any student services guidelines, standards, and frameworks established by State Board of Education and agency. Before the first instructional day of each school year, a school district shall provide to the parents of each student enrolled in the district written notices of each health-related services offered at the district campus, and the student attends. The notice must include a statement of the parent's rights to withhold consent or decline a health-related service. A parent's consent to a health-related service does not waive a requirement of subsection A, C, or E. Before administering a student well-being questionnaire or health screening form to a student enrolled in pre-kindergarten through 12th grade, a school district must provide a copy of the questionnaire to the form or a form to the student's parents and obtain the parent's consent to administer the questionnaire or form. This section may not be construed to limit or alter the requirements of 3804 of this code or chapter 261 family code, or limit a school district's employees' ability to inquire about a student's daily well-being without parental consent. May not be construed to limit, alter, or limit a school district's employees. So it may not limit a school district employee's ability to inquire about a student's daily well-being without parental consent. Not later than June 30, 2024, the agency, the State Board of Education, and the State Board of Educator Certification as appropriate, shall review and revise as necessary the following to ensure compliance with this section: school counseling frameworks and standards, educators' practices and professional conduct principles, and any other student service personnel guidelines, standards, or frameworks. K, subsection J in the subsection expire September 1st, 2025. Section 2604 amended as follows: parent is entitled to access to all written records of school district concerning the parent's child, including attendance, test scores, grades, disciplinary records, counseling records, psychological records, applications for application for admission, medical records in accordance with section 3895, including health and immunization records, teacher school council or evaluations, reports of behavior patterns, So these are the normal ones. This is the one that was added, medical records in accordance with Section 3895. Access to medical records. So just the general access to medical records, it seems, is entitled to access to schools, students' medical records maintained by school district on request. Okay. Records relating to assistance provided for learning difficulties, including information collected regarding any intervention strategies used with the child. Section 109, Section 2608 is amended to read as follows. Right to full information concerning students, except as provided by Section 3804, child abuse reporting programs. Fuck! Page 12. Thank God. Except as provided by the... Except for as provided by subsection or section 3804, which is the child abuse section, or a limited reporting of it. So they do not have the right to inform the parent concerning this. A parent is entitled to full information regarding the school activities of a parent's child and prompt notification of school district employee suspect that an offense has been committed against the parent's child, except as provided by section of the child abuse. An attempt by any school district employee to encourage or coerce a child to withhold information from a child's parent is grounds for discipline under sections 21-104, 156, 211, as applicable, or by the State Board for Educator certification if applicable. Section 110, Section 26 is amended, 2609, that's amended. It's amended by amending subsection A and adding subsection A1, A2, C, D, and E to read as follows. Damn, this leads into the rest of it. So we'll save it here. I'll try to add a bookmark, something. Save as PDF. This will go into legal docs. Texas education. There we go, right here. And we are done with this topic now. We will be coming back to this later because I do not have the mental fortitude to read through a document for ages, and I am running out of time. I have up until 7:40 before my roommate gets here, and after that I am boned. So we have like 10 to 20 minutes to read through, I believe, this. No, this. 16-page document. I have, hopefully. So if you don't know, or you should hopefully know by now, that Trump was indicted by a grand jury 2 days ago? No, yesterday. Yes, yesterday. And the indictment led to 34 charges of falsified records, I believe. Alvin Braggs is having a good time with that. Apparently he did a press conference today and basically said, I don't need to tell you about why I did it. Just the fact that it is. Therefore, have fun, and walked away. Something like that. That's towards the end. I don't know the rest of it. So, either District Attorney or Assistant District Attorney Alvin Braggs did all this. People of the state of New York versus Donald Trump. The grand jury of the County of New York, by this indictment, accuses the defendant of the crime of falsifying business records in the first degree in violation of Penal Law 175-10, committed as follows. The defendant in the County of New York and elsewhere, or on or about February 14, 2017, with intent to defraud and intent to commit another crime and aid and conceal the commission thereof, made and caused the false entry in business records of an enterprise, to wit, an invoice from Michael Cohen dated February 14, 2017, marked as a record of Donald J. Trump revocable trust and kept maintained by the Trump Organization. That's the first count. Second, and the grand jury aforesaid by this indictment further accuses the defendant of the crime of falsifying business records in the first degree. The defendant in the county of New York and elsewhere on or about I wonder if that phrase is in here. There's a phrase I wanted to get out of all this. New York v. Trump. Indictment. This is not good. Is Manhattan... Is this real? Seems like it's the case. With an intent to defraud. Okay, well. So a lot of these are the same, just different dates. The defendant in the county of New York and elsewhere on or about February 14th, 2017, with the intent to defraud and intent to commit another crime and aid and conceal the commission thereof, made and caused a false entry in the business records of an enterprise, to wit, an entry in the detail general ledger for Donald J. Trump revocable trust bearing voucher number 842-457 and kept maintained by the Trump Organization. First degree falsifying business records. February 14, 2017, business ledger 842-460. 14/2017. Check number 000103. Falsifying business records. March 16th, 2017. Where was it said? It was said somewhere that it was a crime or something to not want your name to have bad connotations or whatever. Maybe I gotta find that stream real quick. Here. I found it in the Uncivil Law stream, so credit to him. Go watch Uncivil Law if you watch me, but you probably already watch him if you watch me. Unmute tab. Include the audio.
Civil Law, where we learn through the misfortunes of others. I'm your host on Civil Law, and I apologize. My throat is a little bit sore, so I think I'm coming down with something. So
Oh shit!
in slightly
Rest in peace, Kurt.
And I hope that you'll forgive me. But I wanted to record a short video on the whole Trump indictment situation.
Oh wait, that's 5 days ago, 6 days ago. Here we are. Here's the one.
Are you sick of having issues with your webinars? Wasting
God
tons
damn
of
it.
time on troubleshooting with attendees?
There's a licensed attorney in Virginia and Texas, and we are here today, of
Hopefully
course,
he's feeling better.
with the Trump. The Supreme Court of the state of New York is misleading, because that's what they call their trial level court. The Supreme Court here is misleading, because that's what they call their trial level court. The County of New York, which is basically Manhattan, state and do that. Applied New York business records to conceal criminal conduct.
It was in the introduction? That's not... Where did he find his? DJ Trump SOF. I'm back to Politico, god damn it. Okay, here it is. Thank you, Kurt. Thank you. Hopefully he doesn't get mad at me for including his content. I just needed the portions of it. Original PDF. Sweet. Now fuck off, Politico. Think I might have to end the stream pretty soon. I think that was my roommate coming in. So if you had 3 documents up. Okay. Yep, hold on. Well, seems like that might be the stream today, guys. Went a little late. I didn't meet the time requirements. And I don't want roommate to have to deal with no airflow. It cooled down significantly since yesterday, but still it's stagnant and humid. So, what's it? I'm good to keep going? Like you said, it's cool. So I can keep going? Yes. Alright. Just making sure. Alright, the show goes on, guys. All right, where do I want to go? All right. So this is the introduction statement of facts, or at least their statement of facts. The defendant, Donald J. Trump, repeatedly and fraudulently falsified New York business records to conceal criminal conduct that hid damaging information from the voting public during the 2016 presidential election. This whole thing right here, this is the thing I wanted to get to first. Anything Trump has done, Biden has done worse. Anything Trump has done, Obama has done worse. Let that be very, very clear. Man, it's so great of Alvin Bragg to basically make election misconduct the main focus when he's got fucking Biden and Hillary right there. I'll get into this later. I want to get to the charges right away. I listened to this, so my interest is not quite here yet. So these falsifying business accounts, records in the first degree, so this is the check one. Count 5, falsifying business accounts and the business records in first degree. Michael Cohen, date 2017, transmitted on or about the intent to defraud to it an invoice. Count 5 has to do with Michael Cohen. Count 6 is more voucher numbers. Count 7 is about the check number on March 17th. So this is all proceeding closer and closer to 2018 in April, I believe. 8th count happened in April 13. Michael Cohen, false with the intent. Count 9, June 19th, 2017, voucher number 885-770. Count 10, June 19th, check number 002740, kept and maintained by the Trump Organization. Mind you, all this is about the Trump Organization. They can't really prove all this, it seems like. Or at least from what I hear, it's going to be a very hard time to prove it. Count 11 has to do with Michael Cohen in May 22, 2017. Count 12, May 22, 17, with the voucher number 855-331. 13, account 13, May 23rd, 00, with check number 002-700. Account 14, June 16th, 2017, Michael Cohen. So every one of these, it doesn't really matter what it's based off of. It's a progression towards now. So June 19th, falsify business records in the first degree. 16, June 19th. 17th, July 11th. And the latest one leads all the way to count 33rd. It's 34. Well, I thought it would lead to 2018. And count 34. The falsified business records in the first degree. The defendant in the County of New York elsewhere are on about December 5th, 2017, with intent to defraud and aid in the commission. Donald J. Trump, account and check stub dated December 5th, 2017, bearing check number 003006. These are the indictments for 34 counts of falsified business records in the first degree, all having to deal with Michael Cohen or some kind of check or voucher number. It is a thing. It's happening. It doesn't really matter. It's important, but like, fuck, man. Apparently this is a new era or a new age for the American people to deal with. Something about this has never happened before. And this could be a start of many problems. SOF means statement of facts, doesn't it? Yeah, probably does. Fucking trolled. My friends are off talking in a Discord. But yeah. Falsified New York business records to record and to conceal conduct that hit or damage. All this is basically what is about fucking concealing information or negative information, which is not new for a candidate. We've never tried a candidate on this before. Even the ones that we don't like, we didn't do this. Complete buffoonery. But yeah, I'll get to reading this tomorrow. Right, no, not tomorrow. Roommate will be home tomorrow on his day off. And that'll be my last day. Or my last day off. My schedule has changed. So, I will be streaming more often Wednesday and Thursday, and I'll have to go back to work Friday, Saturday, Sunday. Unfortunately, my weekends are gone. So, I'll try to make all this work out, make it so that my disappearing weekends don't really make that big of an impact. I'll probably stream more on the weekends, actually, more often. I'll try to get at least the 1 hour stream every day. Try to figure out a topic. I think that's what I learned is the hardest part of this is to find a topic. Because without a topic, I don't have much of anything to go off of. And that's a problem. So I will hopefully have that figured out. my work will hopefully create some sort of thinking process for me to create the content. I might be late with some of the content. I might be on time with some of it. Like I was late with this Trump thing. I was really invested in this voucher system because it's relevant to my state. That opinion is important because it matters to how people receive it, and hopefully it'll be received well. I want to see how this functions. Hopefully it'll function well. I don't want it to not function well. The school voucher system seems to be the right idea for how to get school education in a better state. I remember my time as a school student, and I tried to be good or tried to do well at school, and I just didn't focus much about it. At least senior year, it all kind of fell apart. Whenever I was doing education or whenever I was learning in school, my focus on the school stuff wasn't there even before senior year. I understood some of the things, but a lot of it was either because of I just didn't apply myself. It could just be that I didn't apply myself, and that's why I don't have a good opinion. But I had very good stuff to deal with, like choir. I loved singing, so I'll probably get back into some of that. What I did learn has stuck with me for ages at this point. I'm really good at learning. Hopefully I can get someone to mentor me somewhat in the streaming process. I'm hoping to get some kind of guidance, some kind of guidepost along the way. And hopefully I hit the right topic that'll get me up in the numbers. But yes, if you enjoyed this, thank you for coming. Hopefully you were able to handle and deal with my reading skills, as it were, with these documents. I should be trying to read ahead. I don't sometimes, and that creates the problem of my stumbling on words. Hopefully it'll come to me as I'm doing it, and hopefully my whole mouth issue resolves over time, because I'm not used to trying to talk a lot very rapidly, very suddenly, and especially over a long period of time. So hopefully that'll all pan out well enough for me. But yes, like I said, thank you for coming. Thank you for watching live. Thank you, Joseph Declare. Yo! Hey. But yeah, hopefully it all works out. I'll get to be doing this more often. Hopefully I'll have more topics. But yes, I just went through that. Why did I go through it again? I think that was how my idea was to wrap it off. Thank you for coming. Thank you for watching. If you like it, please subscribe for more. Like the video. If you want to support me long term, I have a Locals. I don't do Patreon. Locals, Rumble, and Twitter are all right there in the description. Please go and follow them. Check them out. I think my monetization on Rumble is actually better. So if you want to help me get a kickstart, maybe watch on there instead. But other than that, thank you for coming and have a good evening, good day.